Today I'm going to talk a little bit about what, in essence, leads people to have to file either a Chapter 13 or a Chapter 7. That is, foreclosures, repossessions, and garnishments. Let's talk about foreclosures first. In order to lose your home, here's what has to happen. First, you have to buy the home and enter into a mortgage, generally, to buy it. That mortgage in Tennessee is secured by what's called a deed of trust, where you've transferred to a trustee your home. If you are in default of the deed of trust or the mortgage, the substitute trustee can run an ad 3 times in a paper of general circulation, such as the Knoxville News Sentinel, and sell your home on the courthouse steps. They technically do not have to give you notice, but generally you will get notice. There will be what's called the foreclosure date. That is a very important date because if you do not file a Chapter 13 or a Chapter 7 before those dates, that date will commence. On that date, in all probability, the mortgage lender will buy your home for the amount owed on the debt. You will not have to get out of your home on that day. You will be considered a holdover tenant. The only way that you'll can be kicked out of your home is if they do a detainer warrant. That's where you're taken or given a subpoena to General Sessions Court, and the judge will order you and your possessions removed from the home by a date certain. Sometimes the purchasers of the home will offer you cash for keys so they don't have to go through that process. Repossessions occur when you, for example, buy a car and give a copy of the title to the lender. If you fall behind on the car loan, you are in default. The lender has a right to repossess your car. The lender or the repossession agent cannot breach the peace when they repossess your car. If they can do it without a warrant, as long as it is done peacefully. They can always get a warrant for replevin, but that takes approximately 30 days. Bankruptcy, Chapter 13 or Chapter 7 will stop the repossession from happening. Garnishment only occurs after you have been sued. In order to have your wages garnished, the following has to happen. You have to incur a debt, for example, with either a credit card company or a medical bill, or a finance company. The creditor cannot simply garnish your wages. To garnish you, they have to take out a civil warrant. They have to obtain a judgment. They have to wait till the judgment's final, which is generally 10 days in Knox County General Sessions Court, or 30 days in a general trial court, such as circuit court. After that period, they can have the clerk execute a garnishment, which goes to your employer, directing them to take out approximately 25% of your wages. Again, bankruptcy will stop that garnishment upon filing of the bankruptcy. If you want to stop a garnishment on your own, you can always do what's called a slow pay motion, but you have to get in front of the judge with a budget showing what you can afford. This is just some of the background of legal actions that creditors will take, which is why you might want to consider bankruptcy to avoid some of these harsh actions. Thank you.